In this video, we're talking about powers of attorney. A will and power of attorney are powerful and important documents that provide you with peace of mind and protect your family. They are important parts of any estate plan and together can provide a great many protections as you plan for the future. But what exactly are they? A will is a document that allows you to decide who would inherit your assets after you die. As the testator, you select who your heirs will be and what they each receive. You also name an executor who will be responsible for distributing your assets in line with your wishes. A will can also be used to name a guardian for your children if they are under 18 when you die. They must be signed in front of witnesses. A power of attorney is a legal document that authorises someone else, the attorney, to make decisions on your behalf. If you become unable to manage your own affairs, the person or people you choose will be able to do it for you. Depending on the type of power of attorney you set up, your attorney could be able to pay your bills, make repairs to your home, sell your car, run your business, and more. They can also make decisions about your healthcare. So a will protects your beneficiary's interests after you've died, but a power of attorney protects your own interests while you're still alive, up to the point where you die. The moment you die, the power of attorney ceases and your will becomes relevant instead. There's no overlap. In this video, we're focusing on lasting powers of attorney. There are a number of reasons why you might need someone to make decisions for you or act on your behalf. It could just be a temporary situation, for example if you're in hospital and need help with everyday tasks such as paying bills. Or you may need to make longer term plans, for example if you've been diagnosed with dementia and you may lose the mental capacity to make your own decisions. Mental capacity means the ability to make or communicate specific decisions at the time they need to be made. To have mental capacity, you must be able to understand the decision you need to make, why you need to make it, and the likely outcome of your decision. Some people will be able to make decisions about some things, but not others. For example, they may be able to decide what to buy for dinner, but they may not understand or be able to arrange their home insurance. Alternatively, their ability to make decisions may change from day to day. Needing more time to understand or communicate doesn't mean you lack mental capacity. For example, having dementia doesn't necessarily mean that someone is unable to make any decisions for themselves. But where someone is having difficulty communicating a decision, an attempt should always be made to overcome those difficulties and to help the person decide for themselves. But if you do lose mental capacity, a power of attorney is the key to make sure you are looked after by your loved ones. By setting up a power of attorney, you give someone or several people that you trust the authority to make decisions and to act on your behalf and in your best interests while you're still living and breathing. Once you reach a point where you need someone to act for you, it's often too late to get a power of attorney set up. Once it is set up though, you can forget all about it and hope it never has to be used. One of the most important pieces of advice for anyone with a relative who may need to care at some point is to encourage them to set up a power of attorney without delay. In fact, they're vital for anyone, regardless of your age, who has money and assets to protect, or who wants someone to act in their best interest in terms of healthcare choices if they become unable to make decisions for themselves. There are two types of powers of attorney: property and financial affairs, and health and welfare. If you're still not sure of the importance of a power of attorney, ask yourself how comfortable you would feel if a complete stranger was making decisions about your money, your house, or your health and well-being, including where you live, while your family would be powerless to do anything about it. This is exactly the type of scenario a power of attorney helps to prevent. In that sense, a power of attorney could be considered more important than a will because it safeguards your interests while you're still alive. It's best to get both sorted out though, a will and a power of attorney. It's also a good idea to have both types: property and financial affairs, and health and welfare. You'll need to choose one person or more that you trust completely to act in your best interest. Remember that you want this person or people to fight for you should you not be able to act for yourself or make decisions for yourself while you're still alive. These people are called your attorneys and you are called the donor, because you're giving them power to act. If you wait until you're no longer mentally able to act for yourself, the court of protection may not allow a power of attorney to be set up anymore. Instead, your family will have to apply to the court for a deputyship order. This means that your family will probably have to account for every action and expense on your behalf, including where joint bank accounts are concerned. This can be very difficult, and having to apply for a deputyship can also be a long and expensive process at a time when your family is already distressed about what may have happened to you. Setting up a power of attorney is straightforward and gives you reassurance that if you do become incapacitated for whatever reason, whoever you choose as your attorneys can act immediately on your behalf and in your best interests. If two spouses or partners are making a power of attorney, they each need to do their own. It can be tempting for partners or spouses to choose each other as their attorney, but it's important to consider who would be able to act if both of you are incapacitated at the same time. For this reason, it can be helpful to name an additional person or people, such as a child or a sibling. Spouses should also not assume that one spouse can necessarily act for the other just because they're married. The court may not see it that way. A spouse often needs legal authority to act for the other through a power of attorney. You can ask a solicitor to help you with all of this, and you can do it yourself online depending on your preference. But whatever you choose, make sure you do as much research as you can for yourself first.